Now, tonight on our front, we shine a spotlight on two unfolding controversies shaking Ghana's financial and insurance sectors. I'm talking about the ongoing turmoil at the Bank of Ghana and the legal battle at the state insurance company SIC. At the Bank of Ghana, the minority in Ghana's parliament is raising serious concerns over Dr. Johnson Asiamah's early involvement in the central bank's affairs before receiving the necessary approval from the Council of State. They argue that his actions could set a dangerous precedent, even threatening to report the matter to the International Monetary Fund, IMF. Of course, we have known that the Attorney General's office has actually moved on to actually deal with the matters and have moved to withdraw charges against Dr. Asiamah in connection with the collapse of Unibank and UT Bank. But some of these issues are still being raised by the minority in Ghana's parliament. Over at SIC Insurance, a fierce legal battle is brewing. Former Managing Director Hollister Agyenim-Boateng is challenging her dismissal and the appointment of her successor in a lawsuit filed at the High Court. She claims her termination was unlawful and wants her contract reinstated. Tonight, we break it all down with top legal and political minds. I'll be joined in studio later on by the Majority Chief Whip, Roxanne Nelson Kwame Eche-Dapo, who joins us to weigh in on all of these important issues, especially when the minority is leading the charge against Dr. Asiamah. We'll also be hearing from Dr. Asiamah's lawyers in this conversation. Moses Befi Echampon should join the conversation in the course of this show, as he actually gets to give us some appreciation of the matters. Now we'll move on to also hear from the man who is very active in the affairs of this country. But first, we begin with a legal battle at SIC Insurance. Joining us for this discussion is renowned lawyer Martin Pebu. He joins us now. Welcome, sir, to UPfront.
I'm not renowned. I'm a rookie lawyer.
Well, thanks for the clarification, even though many of us reject that. But to the substantive issue, it is something that happens when governments move in. They end up terminating appointments and appointing new people all the time. Why is the matter at SIC of particular interest? It is the argument of Ms. Yentumi that she was appointed in January 2024 for a 3-year term. I also understand the arguments being made for her is that her tenure has not been exhausted and she deserves some compensation for the termination. And also the difficulty she has with handing over power to James Agyenim-Boateng. Are these legitimate issues of not only company and corporate law, but also proper governance?
Sure, yes. Should I go ahead?
Please do.
Okay. Yes, so let's start this way. Just cut to the chase. One of the key questions we should be asking is, can a managing director be dismissed or terminated in the face of the Companies Act? We need to clarify. So far, I haven't heard that in the discourse, but if you've heard it, you can correct me. You see, when it comes to appointment and termination of directors, it's not just only the Companies Act. So I hear people say, oh, you have to go back to the board, even sometimes shareholder meetings and the rest. But it's the case that, you see, when you go through the Companies Act, you see that if you want to remove a director, you have to lay charges against the director. Then you give the director an opportunity to be heard at the annual general meeting, or if it's an extraordinary meeting, that meeting called by the shareholders, so that the director will be heard in defense, right? That's the normal procedure. But there is also court decisions to show that the common law also applies. So if, let's say, a director misbehaves, has done so many things that are bad, under the common law, the director or MD can be removed. So for lawyers who are listening, we all know the case of Inri West Coast Dying Limited. Adams versus Tando, Ingri West Coast Dyeing Industries Limited, Adams versus Tando. So the main thing is that we are discussing the general law. So as we sit now, we don't know the basis on which the appointment was terminated. So on that basis, no one can stick out their neck to say it is wrong or right, because we don't know. If it turns out that the termination was just done, excuse me to say, for shege reasons, like the way we say, well, shege reasons is our Ghanaian English, so we should be proud of it because the English language is dynamic. I'm not speaking the Queen's language, I'm speaking to Ghanaian. If it's just for shege reasons or to show where power lies, then that's the one you can insist that they should go through procedure. You can't do that. But if it turns out that certain things were done wrongly, there were, infractions of the law, etc., as happened in Adams and Tando, then under the common law, the managing director can be removed. So that's what happened in Adams and Tando. And that's 1984-86 Ghana law report. All right? So let's all become, if not, we may run ahead of ourselves and say, this is wrong, like I'm hearing so far. But you can't say something is wrong nor right until you've seen the evidence. So she has brought out her side. Wait till government responds, or the SIC board, the company responds. Then we would see where to place it.
Now,
that's the first thing.
Generally, there are questions that are being raised by people about the propriety or the lack thereof of the process that have been deployed so far, and I'm sure you've alluded to some of them. For example, some are asking questions about what is the status of the SIC board. This board was dissolved, but can government of Ghana dissolve a board of a publicly listed company where it holds only 40% of its total shares?
No, usually it doesn't come like that. No, unless the shareholders have specifically agreed. Otherwise, it doesn't work like that. The tenure of the board of directors ends, and then they go to the annual general meeting, and then they are appointed. But sometimes, if you borrow money from a bank, it also gives that bank, the power to appoint a director onto the board, and so that one is not, strictly speaking, regulated by the annual general meeting convention. That's if you borrow, and the borrower wants to ensure that it has a rep on the board, so that the rep can be watching out for the interests of the borrower. Yes, that one is not always at an annual general meeting, right? So those are some of the rules that are laid down, the Companies Act.
Now, help us also understand this portion. There is the argument that, indeed, SIC is really not a state-owned enterprise, where the government is the sole shareholder and can dissolve the board at will. As a publicly listed company, the appointment and removal of directors and managing directors are governed by company law and corporate governance practices. Facts?
Absolutely, yes. But that's the one I want. And even if you go to the GST, Ghana Stock Exchange, they even have other rules, right, governing the operations of the company. But as I said, that law also includes the common law. So anybody going about just at 992 may not be given a full opinion.
Okay.
Yes. Press the person that have you taken into account the common law, Adams and Tando.
That's an interesting perspective. I have not heard others respond to that particular question in this particular case now. Now, there is also a bigger issue being raised about whether or not, as we speak, the process should have been this way. And I've seen a write-up suggesting so. In fact, the accusations are the practices when the president nominates or appoints someone as the MD of the institution. The instructions communicated to the Ministry of Finance, which then officially informs the board of the company of the president's nomination. And upon receiving the instruction, the board convenes a meeting to regularize the appointment of the new MD. and simultaneously retire the outgoing MD. It is only after this process that the company formally introduces the new MD to the entire staff. This is the procedure that all managing directors have been subjected to. Is it, to your mind, a prudent procedure?
Yes, that's a normal procedure. Yes, that's why it's done. Because you read the Companies Act 992, they tell you that the board, the directors can appoint from among themselves somebody to the managing director. So the director can appoint from the shareholder doesn't come in. So yes, that is the normal procedure. That when it comes to this, they want to replace yes, really the president, or if I actually now, or formally the finance secretary, would nominate. This is what they nominate first, and we all know that government having huge pay, right? I think they pay for SIC about 44%, right, or something. The percentage, maybe if I got it wrong, but it's quite a huge figure for the government. And also, they also have a huge chance. And where Senate is, usually Senate would not want to do anything contrary to government of Ghana wishes. So certain times where you see Senate, of course, we are all praying that Senate becomes more independent. But right now, most of the time where you see Senate, you just assume that Senate will usually go along with government. So practically, government wields a lot of influence on the in terms of the shareholding of SIC. So practically, yes, government can have its way in terms of appointing a new MD, but usually it should be a nomination, and that nomination will go to the board and let the board confirm.
Now, I need to wrap up on this note, but there is also a raging matter. I mean, all of the issues surrounding SIC has brought up the salary of the MD, which is already creating a storm of its own. 80,000 Ghana cedis. Some say this is outrageous, but the question remains, compared to what?
Compared to the salary of the average Ghanaian, like if you go to the ministries, even chief directors, the chief technocrats, the directors who are the senior civil servants, they don't get anywhere near 50,000, right? So when you look at it, that's where the challenge is. But I also reckon that these are profit-making entities. But when you raise that argument, somebody will tell that the chief director is also working to make Ghana go forward. So it's also profit for Ghana. So that debate will never die. I think eventually we have to rationalize it and see that we should not think that the directors at the ministries, etc., are not making profit for Ghana. They are also making profit because they keep the system, the governance running, etc. Natural fact, Samson Ladi Agyenim, the host of Newsfile, he had occasion to read out this list: allowance for gardener, driver, house help, medical, etc. It's a tall list. So that's like the way Ghanaians have been complaining about Article 71. I think that's the same thing the CEOs of these state-owned or companies, apart from these state-owned companies in which the state has interest, a huge interest, are talking about. So it's good we have the discussion, continue to have it. I know it's not only in Ghana. Even in America, they can show you that the disparity, the difference between the salaries of CEOs and those at the bottom have been increasing over the years. So this debate is very, very important that we situate it in the context that we are not the only ones having that debate. That was one of the reasons that propelled the Occupy Wall Street. And upon that, after COVID, it's even gotten worse, where CEOs are earning far more than the people at the bottom of the ladder. So by all means, I will encourage you, Ray, maybe let's read up and continue more on this discussion so that government will be forced to look at the packages again. Yeah, especially in a country where there's so much unemployment. So ours is more dire. When you talk about America, at least I've lived a bit in America, so I can say, you walk in 1, 2, 3. Anytime we went there, I can tell you that for about 6 years, when we were in university, law school, etc. Anytime I went on summer break, within 2 weeks, I got a job. I don't remember ever staying home for more than 2 weeks without a job. So my point is that even though America, even the disparity is growing, if you want a job, the one that can keep at least to buy foods and basics, you easily get. But here we have in Ghana millions of graduates sitting home. They have no jobs, right? So where the MD is earning so much like that, the pain here is more. So in actual fact, on certain accounts, we can't even compare with America. Another point is that if you look at America and some European countries, you have food stamps. You can go and get free food, etc. Ghana, where are you going to work? I know some churches give a few freebies here and there, right? And also Dr. Abdullah used to feed mad people, so to speak. But here, those little exceptions accepted. Ray, which place can you say today, I'm going, there's a food bank here, I'm going to collect food in Ghana? So the discussion is very, very important. We need to do and rationalize those spaces, cut them down. We have millions of people who are very competent and will also be willing to do the same jobs for less, so that we can cater for those who are unemployed. Yes, we need to do something about this situation.
I get your point, and I'm grateful for your time this evening. Martin Pebu is a lawyer, and he joined us with some understanding and appreciation of what's happening at the state insurance company, where tension is brewing over whether or not the outgoing MD is willing to leave office. She's challenging a dismissal and the appointment of a successor. But that's not the only controversy we are actually following for you today. There is also the conversation about what's happening at the central bank. The minority in Ghana's parliament is raising some concern over Dr. Johnson Esiama's early involvement in the central bank's affairs before receiving the necessary approval from the Council of State. I have been joined on phone now by the lawyer for Dr. Johnson Esiama, Moses Befi Echampon. Moses, you're welcome to UPfront. Moses, I know you're on Zoom, but can you unmute for us? If you can hear me, Moses, I'll be very glad if you could just hit the unmute button so that I can hear from you, every comments, and continue with this conversation. Well, it should be possible that I get Moses into this conversation and get to appreciate this. Now, a few issues the minority have raised. They are first and foremost saying that without a Council of State, the governor cannot take office. They are also saying that they have difficulties with the appointment in and of itself. The appointment of a former second deputy governor as now the governor of the central bank and the leader of the man whose responsibility will be to conduct monetary policy for and on behalf of the People's Republic of Ghana. Dr. Johnson Esiama is the one they are actually raising. They are even threatening to drag the government of Ghana to the IMF and raise issues over whether or not that institution can intervene. That is the crux of the matter. It first started with the minority leader, Alexander Afenyomakin, in a letter. Subsequently, I did hear the very individual by name, the backbencher from Tano North, also raising that in a press conference yesterday. After this break, I'll be joined by the majority chief whip. We'll also be speaking to that lawyer in a second. Welcome back to UPfront. My name is Raymond Darko. I've been joined in studio by the majority chief whip in the very person of Roxanne Nelson Echi Kwame, that Piamapo. I'm almost there. Yeah, we'll make it big. Yes, I hope you're doing well.
Well, I'm okay.
No, you look too good for a man who recently went for a suspension.
Well,
I must say, a very short-lived suspension.
because it was undeserved.
Oh, really? That's interesting.
The whole world saw the role that I played. I was the one preventing the chaos from continuing. I was the one preventing damage from being done to public property. And so, Yes, I must have been caught up in the process to temporarily punish, but...
You mean you are not part of the people who destroyed our tables?
No,
and,
no.
Microphones?
I mean, you saw.
Yeah.
That
at least not in the video.
Yes.
It's not everything that was actually...
Yes, because there were over 30 cameras.
Oh, okay.
Capturing this
from different
melee, as it were, from different perspectives. And as the government chief whip, whose business was being done, it would be unthinkable for me to have engaged in such a manner or such a chaotic situation to prevent my own business from being done.
True.
So
of course, you, on your side, you wanted to continue with them.
Yes, I wanted my business to be done because it's my business. As the chief whip, you are and Afenyo says he has to borrow that phrase from me. I'm the avant-garde of government business. And that when business comes to Parliament, it's the chief's duty to make sure that government's business is done. That is why if I don't have the numbers, I whip him members to make sure we vote on government business and it gets done. My leader is the leader of government business, but once he leads the business to the House, it's my duty as the chief disciplinarian to make sure that the business gets done. So I was simply doing my duty and the law.
What was it with you and Hassan Tampoli?
We are good friends too.
Really? Say we are good friends.
We are both custodians, we are both lawyers, we are very good. You know, that day, you realize that I was with Akando. When I asked Akando should be brought to sit. After we were done with Kofi Adams. So Akando was brought. And I was insisting that, they were saying that we are done, I think we are done 3 or 4. I need to go back. And that they won't continue. I said, but that was not the agreement. They were insisting that there was an agreement. There was no agreement. Because see, we went to a committee meeting. Then, for that Thursday, originally we were to have vetted 6 persons, nominees. But the events of the day before, summoning Voma and all that, truncated. In fact, they said because of our invitation extended to Voma for him to appear, we're not going to do any business. So we didn't vet. Then the decision was that then we should bring those that we couldn't vet on the Wednesday to Thursday. So it affects, naturally it will affect the traffic.
Yeah.
So we had vetted the backlog from the Wednesday. Now we needed to move on to Thursday's work, business. They said no. And in Parliament, if you disagree, we disagree all the time. If you disagree, what do? You boycott. You walk away to go and ventilate your grievances in a press conference, which they had done even in the morning. They had one. Remember, he was calling me a bully that I was bullying them. So you had all those remedies. But to say that you will insist, you will cause destruction, you will stampede the process cannot go on, was untenable to me as the chief whip. So I was insisting that business be done. Then Hassan had an altercation with a very 1100 MP from Western North.
1100 MP.
We use that term.
A fresher. So a backbencher.
Yes, and he was a freshman actually. And he was, and Tampoli was much heavier, bigger than my young man. So I went to his rescue. So I pulled him from the grip of Tampoli. So I pushed him away and I exited. But
it didn't look like the peacemaker.
No, it was.
Really?
So as soon as I entered the fray, then he held my fugu. I was in the smoke.
Yes.
And the smoke in such, so he held me this way. So I said, Hassan, do you want us to fight? You and I, we come for, we are lawyers. So after politics, we are friends. And not that we are lawyers. So if you disagree with this process, you would have seen that I was doing this. If you disagree with the process, you walk, you leave, you boycott, you don't do this. So you look at me, smiled, and left the fugu. And that was all.
No, but that's not what we saw. We saw him gesturing and all of this.
He encountered, we were all talking. So the police came. I said, no, we are not the problem. It's Hassan and his people. So get them out. And this was in a very chaotic situation. So, but everybody saw it. Everybody saw my role and knew that if we're looking for people who truly had orchestrated the chaos, I couldn't be part.
Okay, so that's why you say the suspension was unjust.
It was unjust.
So, I see. I mean, is the committee back to sitting? Is this
the committee, it's a committee of parliament, committee constituted by speaker, and under the rules of parliament, speaker has the power, in addition to standing and select committees, to constitute another committee to deal with any matter that is of some importance to parliament, for which committees have not been provided for. So this is one of them. And the speaker has had the opportunity to form many ad hoc committees in the past.
I need to ask you this question because it became quite viral. It went viral that somebody has had inappropriate access to your private part during the melee. It's
not true. It was a total fabrication.
Really?
Total fabrication. I mean, in that process, who would have gotten the opportunity to...
It was an under-table act.
Yes, but which table? These are people who were taking the tables apart and raising the table. So at what point did somebody sneak under the table to the extent that he got access to? But these are things that...
So you say it never happened or you didn't feel it?
Oh, it never happened. It never happened.
I see. Yeah. Well, now...
If this has happened, 30-something cameras, you think none wouldn't have captured?
They say it happened under the table.
But even under the table, they would have seen because every single gesture was captured on camera. The spectacle that you wore, everything, your hair, everything was captured on from some perspective. So the time the person was ducking and trying to extend his hand to my whatever, it would have been captured.
Well, if you say it never happened, now I need to, because...
So in the event that if it even happened, wouldn't I have been the victim?
Yes.
Exactly. So it never happened. And I don't know why Kwesi Akwa would actually do that. But
now, in politics, that's an interesting perspective.
Yeah.
I need to get this straightened. In the same Parliament of the Republic of Ghana, when President John Dramani Mahama actually appointed the former deputy governor as governor, it was first a statement from Alexander Afeyomakin.
Yeah.
I think the crux of the matter is, in and of itself, the lack or the non-creation or election of a Council of State.
Yes.
And the fact that without that consultation with the Council of State, you cannot do the appointment.
Okay.
And that the man cannot take office and purport to play his role as governor without necessarily going through that process.
Okay. The Constitution is very clear in Article 183(4), I believe.
Okay.
4A. Let me see. With your leave, if I may read for the benefit of viewers. 183. Yes, it's here. Article 183(4). It says, the following shall apply to the governor of the Bank of Ghana.
Okay, 183(4).
183(4). The following shall apply to the governor of the Bank of Ghana. A, it shall be appointed by the president, acting in consultation with the Council of State for periods of 4 years each. So this is the terra firma upon which the governor of the Bank of Ghana was recently appointed. He's my own brother, Dr. Isiama. Now, Apenyo's point is that, and the same provision finds expression in the Bank of Ghana Act 2002, Act, I believe, 612, as amended by Act 918, 2016.
Yeah.
Now, Apenyo's problem is that he went to the premises of the Bank of Ghana to, as it were, conduct official business. So he was questioning the propriety of that. But in doing so, he failed to point out one single law that was breached. Because you see, our constitution creates an executive presidency. Okay? So the president, to the extent that he has the power under 183(4)(1) to appoint the Bank of Ghana governor in consultation with the Council of State. But in the absence of the Council of State as we speak, can nominate a representative.
Okay.
Yes. That is why the president's letter appointing all heads of state institutions puts them in a temporal capacity, in an acting capacity.
Okay.
And that's the same tone that they use for Dr. Isiama, for the Bank of Ghana. Is the honorable minority leader saying that Dr. Isiama, in that capacity, in that acting capacity, as the governor of the central bank, cannot engage officially, cannot take briefings? In his own letter, at paragraph 7, I believe, now advises that before receipt of the consultation, whichever form it takes, and I'll get to that shortly, whichever form it takes from the Council of State when it's properly constituted, he can receive briefings, formal briefings. So I asked the question, now, if you are encouraging the man to receive formal briefings, wouldn't the briefings be conducted in the premises of the Bank of Ghana? So you see, Appenyo just engaged in what we call mischief, and it was actually hot air. He got it wrong. There's a distinction between these two phrases as used in the Constitution, in consultation with, and prior approval. In respect of some appointments, the framers use the phrase with prior approval. When they use the phrase prior approval, like appointments of ministers of state, the president will nominate with prior approval of parliament before they are appointed. Now, parliament, by its own design, has formulated guidelines for satisfying that prior approval. So what do? You communicate the nominations to parliament, to the speaker. Speaker will refer those names so nominated to the appropriate committee, in this case, the appointments committee. The appointment committee will schedule the nominees to appear for interrogation. That's what we call vetting. Now, before you are vetted, the appointments committee will cause to be published information that you've been nominated to occupy so and so and so and so office. So if any member of the public has information adverse, they can bring a memo, they can bring petitions. That is the prior approval process that Parliament has designed for itself. Now, when you clear that prior approval process, the president now appoints you. The appointment is the swearing in, where you are sworn in and you are giving your warrant of office. You know what they hold?
Yes.
That's the warrant of office. Without that warrant, you can't go and occupy the office. So it's quite elaborate. Now, when you get to the other provisions that says you appoint in consultation with, Council of State has no formula. They have no design for satisfying that in consultation with. So the consultation with could say that, could come in a form of a memo to the president that you have referred to as names of persons you intend to nominate for, say, like Bank of Ghana, like it's captured in under Article 1834A. We have the opinion that he's qualified, so please proceed. So it takes the form of a letter. Those letters, we often don't see them. All right?
I get you.
Yes, they are not often made public. So the Supreme Court, my same brother, Appenyo, in 2016, he litigated this matter when some persons were appointed. So he led the GBA, the Ghana Bar Association, and some other persons, and went to court. So the court, some other persons also came. So the court consolidated the case. So it was GBA and others versus AG and others, 2016. Now, the Supreme Court had cause to pronounce, to straighten these issues. The Supreme Court said, look, this pre-approval and all that, it's not binding on the president. So, in fact, the president...
Is it consultation or prior approval?
No, prior approval. They distilled the law in respect of both.
Okay.
And concluded that even with these two phrases, distinct phrases, those recommend prior approval, when Parliament actually approves of you, and you are supposed to be actually appointed, the president can actually change his mind.
Oh, okay.
Yes.
Reverse the appointment.
Yes.
All right.
And because the prior approval, where Parliament will say, a report has been presented, laid, debated and adopted, and a resolution is passed that so and so and so and so and so
have been approved.
Have been approved. When it's communicated to the president may not proceed to appoint you. And the Supreme Court,
but it doesn't hold on. You can do without that particular process.
Exactly.
All right.
All right. But the Supreme Court says they are not binding on you. You understand? So technically speaking, the president has the power to actually have somebody to represent his interest at the Bank of Ghana, even though it's a creature of the Constitution, by saying that that advice in consultation with or in pro-approval is not binding. In fact, Justice Doche, in giving a concurrent opinion, Doche JSC as it then was, in giving the concurrent opinion to the opinion expressed by Atuguba JSC as it then was, said, look, in concluding, they are constitutional requirements, prerequisites, but they are not binding on the president. So the president can actually have somebody represents his interest. And recently, I went to court against the president when the president asked, Nana Akufo-Addo, yes, then, as it then was, okay, when he asked that after he was retained in office, second term, then he asked his DCs to stay on. So I challenged that directive. He said they should stay on, but they should not engage in policy decisions. I went to the Supreme Court. The Supreme Court said, this is an executive president. Even though by the constitutional provision in Article 242, the nomination, if you nominate somebody as a DCE, it is subject to the approval by the assemblyman. The fact that he can actually ask them to stay on is regular.
Okay.
You understand?
That's what the court ruled.
Yes. That's so I lost the case technically because I was asking that the decision to ask them to stay on beyond his 4-year mandate was wrong. They said, no. This is an executive president. He can always ask somebody to represent him in those capacities.
I see. But the capacity within which Dr. Siama is acting,
yeah,
can he do all things?
He can do all things.
As governor?
He can do all things.
Without limitation?
He can do all things.
Without any indication that this is a far-reaching decision that a person in acting capacity shouldn't be able to make? He
can do all things because the Supreme Court says that in consultation with phrase requirements, okay, by the Constitution. So whether the Council of State, okay, in exercising or in satisfying that constitutional requirement in consultation with advises the president that no, don't look, Raymond, don't appoint him, don't proceed with the appointment of him as governor of the central bank. The Constitution says, the Supreme Court says, it's not binding on the president. So he can actually proceed to keep you there.
I heard,
yeah,
I think it was a member of parliament who had raised at a press conference yesterday an issue to do whether or not they can report this to the IMF.
They fell into an error of law. So you will see that I tweeted this matter. And I said that my brother Agyenim-Boateng fell into an error of law. Mm-hmm. You know, so it is hot air. There's no law has been breached. That is why they cannot point to any law that is being breached. Because Dr. Siama is regular in office. Mm-hmm. He can proceed to conduct business in his capacity as the governor of the central bank. Okay. Whether pro-approval is satisfied with the receipt of the opinion from the Council of State today or tomorrow.
Is he expected to be sworn in?
There's nothing like swearing in.
For governor?
No. There's nothing.
Okay.
He's appointed in consultation with the Council of State. And that consultation can be ratified tomorrow.
But as we know, there's no Council of State today.
Yes, so when the Council... Hold on. So when the Council of State... That is their argument. But Afenyo himself got that problem solved in 2016.
When he went to court?
When he went to court. So you see the constitutional provision...
Is it that your understanding of what the court said is different from his understanding of the government of the case, the paper, and its application in this matter?
He is the lawyer, so I want to believe that he understands the matter better than me, because he actually advocated for the plaintiffs, and he lost.
I get you, but is it not the more reason why you may have to give him the benefit of the doubt and lean more towards his interpretation of what should happen under that circumstance and the possible distinguishing elements here?
No, because the courts disagree with him. So the appropriate thing he ought to have done was to have proceeded to for a review.
Okay.
In the consolidated matter.
But it didn't happen.
He didn't go because he got convinced by the position of the Supreme Court. So once you got convinced by the position of the Supreme Court, you cannot persist in canvassing the law that you canvassed before the court and lost.
Okay.
So as I see it, he's still canvassing that position today.
Which is dismissed by
which was rejected by the court in 2016.
Okay. So if they report to the IMF, what happens?
But what report would they be sending to the IMF?
That they believe that they should not be dealing with a man who is not being properly being put in office.
What is the meaning of properly? As the president says, the president has power under Article 83, 183, 4A, to appoint a Bank of Ghana governor in consultation with the Council of State. Yeah. So are they rather saying that, as we speak, there should be no governor of the central bank properly so called when the one that is there has proceeded on terminal leave?
No, they're not saying so. I mean, it's procedure that they are dealing with. I mean.
So there's no lacuna in the law.
Okay, that's what
there's no lacuna. So they are blowing hot air. They have no complaint before the IMF. They cannot go and complain about anything. Well, they are playing political mischief. yes. And they know it.
Now, the statement that was also put out, subsequently, Agyenim-Boateng read a press conference of a sort and said, "We are at a loss as to why President John Mahama cannot wait for the completion of the adjudication process of a court suit against Dr. Esiama before appointing him."
Has somebody sued Dr. Esiama?
I thought there was a case some time ago.
Which case? Dr. Boateng is not abreast with current events.
Latest developments.
Because the Republic, which is the state,
that took him to court.
Look, criminal matters are conducted at the behest of the state. It's not, we as private citizens, we don't have the power to institute criminal proceedings against anyone. If you are aggrieved by my conduct criminally, or I'm aggrieved by your conduct criminally, or you are aggrieved by the conduct by somebody criminally, the procedure is to make a complaint to state institutions. For them to conduct prosecution if you are so minded, if you feel strongly on your behalf. So you only become a witness. You are a victim, but you become a witness for the state. So your case, even though it's a private interest, now is subsumed by the interest of the state. And that interest, the states can always depart from it. So Agyenim-Boateng should know that the matter the state supposedly brought against Dr. Esiama, and I think 5 others. The same state has come to say that I'm no longer interested in the matter. No le prosecute.
This happened somewhere January 31, 2025.
Of course. And by February 3, he's been appointed.
Yes.
That's how beautiful this world is.
So now, the case was dropped, he's been appointed, and yet the minority MP is convinced that they should wait for some case to be dismissed.
So, no, he's not convinced. He's dealing with a matter that is moot. He's not abreast. So let me educate him that so much water has passed under the bridge since. So he should get himself abreast with current events. There's no matter against Dr. Esiama.
Yes, and I mean, the story says that the Attorney General has filed a notice to drop all charges against Johnson Pandit Esiama, the former second deputy governor of the Bank of Ghana, who's been on trial on 2 different cases involving the failure of UT Bank and Unibank. Yvonne Atakra Obobisa, the director of public prosecution, signed a notice of withdrawal that was submitted to the trial court. It follows. Please take note that the prosecutor has withdrawn all charges. The expression here is has withdrawn all charges and all offenses against Johnson Esiama under sections 59(1). 2BII and 5 of the Criminal and Other Offences Act. And at the next hearing of this court, the Honorable Court's instructions, charges of fraud has been brought against and all of that. The former secretary was accused of UT Bank's failure together with 5 others. And so this is a non-matter.
It's a non-issue.
It's a non-issue in
Look,
the first place.
Dr. Agyenim-Boateng is on a journey to nowhere.
Okay.
And this, you see, these are the kinds of mischief they create, they engage in. He knows. Agyenim-Boateng is a member of parliament. He knows that between the 31st of January 2025 and the midnight of 3rd February 2025, these things have happened.
All right.
And yet he will issue a press conference ipso facto the events or ex post facto the events of 3rd February and insists that there's a matter pending against Dr. Johnson Esiama.
I understand that Moses Befi Echampo, who is lawyer for the governor of the Bank of Ghana, is on the line. Let me hear him briefly on this matter. Mr. Echampo, can you hear me now? Sorry, you can hear me, right?
I can hear you clearly.
Brilliant. Now, clarify this for me. Is there a case by the state against Johnson Esiama as governor of the Bank of Ghana, former second deputy?
The state has withdrawn any charges against Dr. Johnson Esiama. And so currently there are no charges pending against Dr. Johnson Esiama.
Now, there is also a case about whether or not he's been properly put in office as governor. What is Dr. Esiama's view on this particular issue being raised by the minority, which amongst other states that until Council of State is brought in and consulted, he cannot take office?
I don't see anything wrong. I think the proper thing has been done by the President of the Republic. Dr. Johnson Esiama has been rightly nominated to be the governor of the Bank of Ghana. Let me take this opportunity to highlight on some of the issues Dr. Boateng raised in his press conference. Dr. Boateng failing to understand or has lost sight of the fact that an accused person is only an accused person, and even in some countries is referred to as a defendant or a respondent, and is innocent until proven guilty. He has also forgotten that the Attorney General has the discretion at any point in time to decide to discontinue a matter against any accused person. This is a matter that has spanned for about over 7 years. In fact, there are over 10 prosecution witnesses in the matter. We are done with the first and the second prosecution witnesses. We are now moving on to the third, and this is after about 7 years. In fact, the last time we were in court, prosecution indicated that they are finding it difficult to get to the third prosecution witness, and so took a date for adjournment. If you look at the fact of the case, you look at the witnesses tendered in by the first prosecution witness and the second prosecution witness, no person will come to any other conclusion than to say that the case against Dr. Johnson Esiama has no substance and ought to be discontinued. The state cannot continue to waste its resources on something like that. Out of the about 68 charges, there are only 2 against Dr. Johnson Esiama. One, that he breached the Bank of Ghana Act, and 2, that he caused some financial loss to the state. However, when you look at the facts, you realize that Dr. Johnson Esiama was only executing tasks that were, or decisions that were taken by management of Bank of Ghana. He didn't take any personal decisions on his own. And so I am not surprised at all that the Attorney General has reviewed the facts, reviewed the evidence tendered in so far, and has come to the conclusion that the case ought to be discontinued against Dr. Johnson Esiama, who was rather serving the country, somebody who has such wealth of knowledge and has served the country, and the president intends such a person to head the Bank of Ghana. I don't see why such charges should be pending against a person who is such an officer. And so I don't see anything wrong. Everything has been properly done, and it's in the right direction. And so the minority should come again on their press conference. The press conference, to me, lacked the substance it deserves and shouldn't even be given any attention at all.
Mosi, thank you so much for joining us. Final words before we leave the studios here, Honorable. Going forward, are you still going to be able to do vettings without any fight at all?
Yes. Indeed, yesterday, I'm certain that you must have known by now that 14 nominees have been named by His Excellency the President and since been released for the information of Parliament. The referrals have been made pursuant to Outstanding Order 3, where some key provisions of Outstanding Orders are waived expressly for work to be done. So tomorrow we are meeting the Appointments Committee. We have in-camera meeting to, as it were, schedule hearings for next week. We are likely to do 4-4-4-2. Okay. Because there are 14 in all.
That's true.
So we'll work in peace and tranquility. But let me add, it appears that the pain of the minority is that Dr. Siama is occupying the new building. Apparently, actually said it, that to the extent that because
but you opposed that building. You opposed the building.
No, we didn't. No, we didn't oppose the construction of the building. We opposed the cost. Okay. That ballooned from $85 million to now in excess of $280 million. We have even asked for parliamentary inquiry into that. As for the building, we'll sit in it, but we'll check. We'll question the cost. That's our duty.
I am grateful to you, Roxanne Nelson, Echikwame, for joining me in studio. It's Majority Chief Whip.
So pained I sit in the new office.
Thank you so much once again for coming in studio. Many thanks to you for joining us on today's edition of UPfront.
My pleasure.